Hello, I'm Alan Wilson. Recent events surrounding the removal or tearing down of historical monuments have led a number of people to call into question the constitutionality of the Heritage Act and its applicability to specific monuments in South Carolina. There are two issues I would like to address. The first issue involves the overall constitutionality of the Heritage Act, and the second issue involves my office's position on the Act's applicability to the John C. Calhoun Monument on Marion Square in Charleston. First, I would like to address the question as to the constitutionality of the Heritage Act. My office has looked at both arguments for and against the Heritage Act and has concluded that the Act and its protections are constitutional and that only an act by the South Carolina General Assembly can remove a monument. This is a position we are prepared to support in court. You can read the detailed official opinion of this office if you're looking for legal citations, but here's the basic legal position summed up. There are two main provisions of the Heritage Act. The first provision is a substantive part of the Act. It lists the criteria that a monument must possess in order to be afforded the protections of the Act. The second provision is the procedural part of the Act. It describes what must be done to remove those protections and take a monument down. The first provision is the most important because it contains a description of which monuments are protected. In other words, the guts of the law. The second provision provides that the South Carolina General Assembly can only remove a monument with a 2/3 vote of both the House and the Senate before it can be sent to the governor for signature. Some critics of the Act have claimed that the 2/3 vote requirement is unconstitutional and therefore the entire Heritage Act is unconstitutional. There are several problems with this legal argument. Here they are. We agree that a court would likely find that the 2/3 vote requirement is unconstitutional because under our state constitution, the General Assembly is only allowed to pass laws by a simple majority vote. A General Assembly from 20 years ago cannot bind the General Assembly of today to a new supermajority vote requirement. However, there is a legal precedent used by the courts whereby the court will literally read out the invalid procedural part, which in this case is the 2/3 vote requirement, and then apply the valid simple majority vote in order to uphold the substantive part of the law. Also, when the Act was passed in 2000, it included a severability clause, which basically means that if any part of a law is found by a court to be unconstitutional, it is severed out and the remaining law is saved. The second issue I wanted to address deals with questions regarding the applicability of the Heritage Act to the John C. Calhoun Monument in Charleston. Senior members of my legal team and I looked at the specific facts surrounding the Calhoun Monument and whether or not it was protected by the Heritage Act. The Heritage Act is very specific in some places as to what it protects and ambiguous in other places. For instance, the first provision of the Act protects war monuments and monuments for Native Americans and African Americans. John C. Calhoun does not fall under any of those categories. Another provision requires the monument to be in a public area, and the Calhoun monument was on private property. Furthermore, as we researched the Calhoun monument issue, we reached out to supporters of the Calhoun monument, including the organization that owns the property where the monument was located. An attorney for this organization was of the same opinion that the Heritage Act did not apply. We also learned that the group received assurances from the city of Charleston that the statue would be cared for and protected until a suitable location for it was found. Our legal analysis of the law's ambiguity, coupled with the organization's understanding from the city of Charleston that it would protect and care for the statue until a suitable place was found for it, led us to the decision to not file a legal challenge at this time, but to instead focus on the overall legal defense of the Heritage Act. My defense of the Heritage Act is not a defense of those parts or acts of our history that we find abhorrent. My defense of the Heritage Act is based on my sincere belief that we should follow the rule of law. This means following the laws that our duly elected legislature has passed and prosecuting those individuals who intentionally flout the law by illegally destroying public property. Instead of tearing down history, I believe we should add to it. I suggest that we work instead to provide historical context to the bad acts of those who have been immortalized in stone, so that future generations will know what we as a people had to overcome. Next, we should work to immortalize people from all races and backgrounds who have worked and suffered to make us a better society. Thank you.